All right, my friends, Eric Lee here with Equity Real Estate and Elite Agent Training. And I've had a request due to a substantial amount of problems in the state with limited agency. Now, in Utah, this is legal to be a limited agent or represent both parties at the same time. However, it doesn't make it easy and it doesn't always make it right. And so what we're looking at here on the screen is an excerpt from the law, the administrative rules. And let's see, we're on the section here. If I go up here, let's see, affirmative duties required of licensed individuals. Okay, so that's the section that you're going to look for. And we're going to jump down under section 3. All right, if you're representing both principals in a transaction as a limited agent, you obtain prior informed consent. Now, we all know that there's a limited agency form. So let's talk about that form really quickly. And then let's talk about going beyond and actually what the law requires of us rather than just signing the form. Because a lot of people just put the form in front of them and they're not really explaining what that means to the client and what their options are and their rights are. So when do we use, well, let's first of all define limited agency. The obvious one is when I'm representing, let's say that I'm representing the seller and an unrepresented buyer comes to me through some of my marketing and I end up representing the buyer as well. So I'm representing both parties. That's clearly limited agency. However, it's also limited agency if I'm representing the seller and an agent from my office brings a buyer in. Now we're limited under our branch broker. So the branch broker has this limited agency. So we still need the limited agency form in there. Now, in some cases with some of the bigger offices, my office in particular, we're the largest company in the state with 17 different branch offices throughout the state. If any one of those agents from one branch office to another branch office brings an offer to a listing agent, and so both agents are with Equity Real Estate, again, we have a limited agency situation with the principal broker as the limited agent. So the principal broker would need to sign off on that, right? So that is limited agency. Whether it's you representing both parties, somebody from your office, different agents representing both parties, or it could be somebody even from a different branch if you're all under the same principal broker. So if that's the case, then we would sign the limited agency form. But the law says that we need to do a little bit more. We need to clearly explain in writing to both parties. Now, the form does clearly explain it in writing. Are we taking the time to go over that form with our clients? They need to understand that they can each be represented by a separate agent. So even if an unrepresented buyer comes to me, they need to understand that they do have the right to have their own agent. They need to understand the type of information that will be held confidential and the type that will be disclosed. Because again, with limited agency, we have this fiduciary duty. And in fact, if we go up just a little bit more, the very first section up here talks about fiduciary duty. So let's look at this really quickly. The fiduciary duty is loyalty, which obligates the agent to place the best interest of the principal above any other interest, including the agent's own. Obedience, which means that we're going to obey any lawful instructions from the principal. Full disclosure, which obligates the agent to inform the principal of any material fact the agent learns about, which could be regarding the other party or the transaction. And confidentiality, which prohibits the agent from disclosing without permission any information given to the agent by the principal that would likely weaken the principal's bargaining position if it were known, but accepting any known material fact concerning a defect in the property or the client's ability to perform reasonable care and diligence, and then holding safe and accounting for earnest money and any other additional duties created by the agency agreement. So if you paid attention for that, hopefully you did. I know I'm going really fast through here, but if you paid attention through that, some of those things you cannot do with limited agency, because this expectation of confidentiality and also full disclosure, how do you keep confidential and fully disclosed when you're representing both parties? Things that can't be disclosed. And so this has to be discussed with the client so that they understand what your limitations are in your fiduciary duty and how that could possibly impact them. So the circumstances under which the withholding of information would constitute a material misrepresentation regarding the property or regarding the abilities of the parties to fulfill their obligations. Again, one of the things up here in this one, it's in D, says that we do need to disclose any known material fact concerning the property or the client's ability to perform on the contract. That's defined as a material fact, and that would need to be disclosed down here under limited agency. All right. So, anyways, when acting under limited agency thing, we've got all of these things that we need to have a discussion with our client, and with both clients, making sure that they understand. And if they don't like the situation, then they should have the opportunity to get their own separate representation. All right. Now, let's see. Okay, so we're up here under B now, obtaining a written acknowledgement from each party, affirming that the party waives the right to undivided loyalty, absolute confidentiality, and full disclosure. Again, those three things as a part of the fiduciary duty cannot be given, and this written acknowledgement is a part of that limited agency consent agreement form. All right. And then the last part of that section 3 is get a written acknowledgement from each party affirming that they understand the licensee will act in a neutral capacity to advance the interests of each party. And then section 4 also applies. It says when you're acting under a limited agency agreement, you're going to be a neutral third party. You're going to uphold the following fiduciary duties to both parties, which is obedience, which obligates you to obey any lawful instructions from the party, reasonable care and diligence, and holding safe any money and any other additional duties. But there are a few things, you'll notice a few of the fiduciary duty items that are defined up here that aren't down there, all right, that are specifically excluded under a limited agency agreement. So to summarize all of this, you need to sit down in any type of limited agency situation, you need to sit down with the limited agency consent form, not just have your client sign the bottom of it, but you need to go through that because the law requires that you do. Go through it all, make sure that the client understands. Now, once they understand, does it mean that every situation where it could be a limited agency is okay? And the answer is absolutely not. The number one problem with or complaint against agents in a limited agency situation is that if something goes south, one of the parties always feels like they didn't have the agents, or the agent didn't have their best interests at heart. Feels like the agent was favoring somebody. So just a quick word of advice from me. Now, this is my opinion. We've already covered the law. Now we're getting into my opinion. All right. My opinion is if you're representing a family member or a close friend, then you should not be in a limited agency situation. Now, if you're representing yourself, you cannot be in a limited agency situation because the law does specifically prohibit you from being a limited agent and one of the principals in the transaction. So you can't represent the seller and buy the property yourself. You can't be the seller and represent the buyer. That's forbidden. But going beyond that, if I'm representing a friend or a family member and selling their home, and then I have a buyer come along and have them sign a limited agency agreement, there is a very strong chance at the end of that transaction that buyer does not feel like their best interests were taken to heart by that agent because he had a previous existing friendship, family relationship with the other party. And so I would avoid having a limited agency situation where you're representing both parties there. You could engage the services of somebody else from your office. It's still limited agents. It's still limited agency, but you're not representing both as one individual. All right. So there are workarounds to do that. And yes, you're potentially passing up some commission. But again, when we go back up here to fiduciary duty, it says that we put the best interest of the principal above any other interest, including the agent's own. So yeah, you might be passing up a little bit of commission there, but if it's in the best interest of one of your clients, then you need to do that. Okay. This affirmative duty is required of all licensed individuals. Put your client's interest first. So examine that very closely. And if you're uncomfortable with it for any reason, or your clients are uncomfortable with it for any reason, either buyer or seller, then make sure that you bring in somebody else that can help them, and they have that right to have their own representation. All right. So just because the law says it's okay, once you've explained everything, maybe it's not so okay. Maybe you need to make sure that you are putting this loyalty aspect of affirmative duties of your fiduciary duties into play and make sure that your client's interests come before your own. Thank you.